Welcome viewers. When Law Changes Australia, final episode, the constitutional question, Hanson left Australia. Have you ever wondered whether Pauline Hanson really lost, or whether Australia inherited a constitutional question that still deserves an answer? The Mehreen Faruqi appeal ended with a unanimous judgment. Section 18C remained constitutionally valid. The court dismissed Hanson's appeal, and that's where the legal case ended. But according to the constitutional critique explored throughout this series, another question remained. Not whether Section 18C should exist, not whether Hanson's words were right or wrong, but whether the constitutional reasoning supporting the legislation remained completely consistent from beginning to the end. The court explained why Parliament had the constitutional power to make Section 18C. The court also explained why Section 18C could constitutionally burden political communication. And those explanations answered different constitutional questions. The critique examined in this series asks whether the principal constitutional justification supporting the legislation remains sufficiently consistent across both parts of the reasoning. Reasonable lawyers disagree. The court reached one conclusion, the constitutional critique reaches another, and that's how constitutional law develops. Not through slogans, not through outrage, but through careful examination of constitutional reasoning. Whether one agrees with Pauline Hanson, whether one agrees with Faruqi, or whether one agrees entirely with the full federal court, every Australian has an interest in one enduring constitutional principle. The Constitution should be applied consistently. Its reasoning should be transparent. Its foundation should be clear. Because constitutional certainty belongs to every citizen, not only those who stand before the bench. And perhaps that's the real legacy of Hanson versus Faruqi. Not that it answered every constitutional question, but that it reminded Australians that constitutional judgments can continue to be respectfully examined long after the courtroom has fallen silent. And that's not a challenge to the rule of law. It is one of the ways the rule of law remains alive.